So hopefully you're nice and cozy in front of your computer and you're very excited about this upcoming CLE today. Um, as a heads up, we have a CLE coming again on March 5th, and that CLE will be addressing sentencing advocacy from arraignment through appeal. So it's a program designed for trial and appellate counsel. So look for information on that program to be distributed soon. As for the other usual housekeeping matters, CLE codes, you will get 2 of them today, and make sure that those forms are returned to Lillian by February 6th. We will take questions at the end of the program. I noticed that Phil Rothschild has already started us off with one, but we'll wait till the end to address your question if that's okay with you, Phil. And I don't want to take too much time away from our presenters. We have today with us Sarah Goldfarb from the Statewide Appellate Support Center at ILS, which, as you all know, is available for consultation on all your trial and appellate questions, as well as Tom Leaf. He's an associate teaching professor, and director of the Criminal Defense Clinic from Syracuse Law. So that's enough for me. Please join me in welcoming Sarah and Tom.
Thanks, Jane. Welcome to Avoiding Anders, a CLE that will offer strategies for effective communication and advocacy in criminal appeals. As Jane said, I'm Sarah Goldfarb, an appellate attorney with the Statewide Appellate Support Center at the Office of Indigent Legal Services.
Hi, everybody. I'm Tom Leaf, and Sarah and I used to work together, as a matter of fact, at Hiscox Legal Aid right here in Syracuse, so it's fun to be together again doing this, Sarah.
Definitely. Thanks, Tom. So before we get into the presentation, I want to take a minute to share a little bit about the Statewide Appellate Support Center. We were launched in 2022 to provide support to appellate, post-conviction, and trial counsel, as well as interdisciplinary defense team members who are providing mandated representation in criminal and family defense. Our team does not provide direct services or legal representation. There's an option, I think, for other people to take control, and I would just ask you not to do that. So as I said, our team does not provide direct services or legal representation. However, we do provide consultations, trainings, and resources. Our consultations can be case specific, like mooting oral arguments, brainstorming on legal strategies, conducting legal research, reviewing written materials, or connecting attorneys to experts. Our consultations can also be issues-based, like figuring out ways to collaborate with social workers and mitigation specialists. Similarly, our trainings can be issues-based, skills-based, or systems-based, and our resources include statements of law, guidebooks, and templates. In addition to the attorneys on our team, we have a paralegal, a special assistant for investigation, and a special assistant for mitigation, who are also available to consult with defense teams. Today, we're going to be talking about Anders briefs and client communication in appellate practice. These 2 topics go hand in hand because when we communicate effectively with our clients, we can find alternatives to filing an Anders brief. Our goal today is to give you some practical tools you can use when you come across an appellate record that doesn't appear to have any viable issues. We'll start by covering what an Anders brief is, why you should avoid them in your practice, and what you can do when you have a case that doesn't appear to have any appealable issues. Then we'll talk about client communication, ethical concerns to keep in mind, how to answer the hard questions that inevitably come up, and what to do if you suspect your client has diminished capacity. So what is an Anders brief? Before we get started, I just want to flag that a lot of what we'll be talking about today is also included in the Anders Practice Advisory that's included in your materials. So an Anders brief comes from the Supreme Court's 1967 decision in Anders v. California. In that case, appointed appellate counsel submitted a letter to the court stating that he believed the appeal had no merit, asking to withdraw from the case, and advising the court that he had communicated his opinion to his client. The Supreme Court rejected this no merit letter process, and instead the court emphasized that appellate counsel must act as an advocate, not as an amicus to the court. To discourage attorneys from designating cases as having no merit and seeking to withdraw on that basis, the Anders Court decided that if an attorney wants to withdraw from an appeal that they believe has no merit, that attorney would need to file a brief that identifies every conceivable appellate issue and then explains why all of those issues are frivolous. By requiring attorneys to file an Anders brief rather than a simple no merit letter, The court incentivized attorneys to prepare a brief on the client's behalf, even if only to raise a weak issue, since filing an Anders brief would require just as much, if not more, work. So what does Anders require? Under the Anders procedure, counsel begins by conducting a conscientious review of the entire record. We'll talk more about what wholly frivolous means on the next slide, but if counsel believes that the appeal would be wholly frivolous, counsel must file an Anders brief that, as I mentioned before, identifies any potentially arguable issues, even if counsel believes that those issues ultimately lack merit, and explains why raising those issues would be frivolous. The client also gets a copy of the Anders brief and is given an opportunity to file a pro se response. And once that is done, the final decision about whether the appeal is wholly frivolous is made by the court and not by appellate counsel. So while Anders lays out the procedure, it leaves a critical question unanswered. How do we decide whether an issue is wholly frivolous in the first place? Since the Supreme Court doesn't define wholly frivolous in Anders, we need to look towards other decisions to get a sense for what they meant. In 2000, the Supreme Court in Smith v. Robbins explained that an arguable issue, in the normal sense, is one that is non-frivolous and therefore warrants a merits brief. And in 2019, the Second Department in People v. Murray advised that appeals that present issues that may be arguable on their merits, even if weakly or marginally so, must be perfected to fulfill the defendant's right to receive and the attorney's obligation to provide zealous representation. On that note, I want to ask you to think about if you've ever prepared for oral argument, carefully considered and selected the issues from your brief that you thought the court would be most interested in discussing, and then arrived at the podium for oral argument to find that the first question the court asked was about an issue you weren't planning on discussing at all because you didn't think it was particularly strong. I know I've gone into an oral argument thinking that my best chance at getting relief for my client was in my point 1, only to find that the issue the court wanted to discuss and ultimately reversed on was in my point 3. It's a good reminder that our sense of what is an interesting or persuasive argument doesn't always line up with the court's opinion. And now I'm going to pass it on to Tom to talk about the problem with Anders briefs. Tom?
So the problems with filing an Anders brief are essentially twofold. One is that it does create a conflict of interest with your client. And two, it's probably going to get rejected by the court, which has a couple ramifications that we'll discuss. As for conflicts of interest, as we know, we have a duty to zealously represent our client and not to take a position adverse to our client's interests. And that's exactly what an Anders brief does. And moreover, clients feel unheard and that their concerns are not being voiced once you're filing a brief on their behalf saying that they don't have a case. So both of those things do kind of create a conflict of interest between you and your client. So in essence, it's zealous representation versus, sorry, we have no argument. Next slide, please. Sorry. Okay, so the other problem is that appellate courts regularly reject them. And when this happens, new appellate counsel is assigned, the resolution of the appeal is delayed, and there's been a lot of waste of time and resources. And it's a big waste of your time. Probably doing an Anders brief probably is much more work than doing a brief where you found some issue, maybe not a great issue, and you end up briefing it. So an Anders brief is going to be far more work than that. And worse, if the appellate court rejects your Anders brief, it's going to be for one of the three reasons you see here. It's going to be because the court has found the presence of a non-frivolous issue, that there are other deficiencies in the brief, or obviously, worst of all, the brief reveals ineffective assistance of counsel on your part. And appellate courts don't like Anders briefs, and it's especially embarrassing if one gets rejected. So there's reputational harms involved as well, in addition to the waste of time. Turning to Sarah.
Okay. So how can you avoid filing an Anders brief? I think we've all had the experience of reviewing a new file and feeling like everything went right. Your client pled guilty early in the process and received the minimum sentence, and there aren't any appellate issues jumping out at you. That's the moment when an Anders brief might seem tempting. But just because nothing is jumping out at you doesn't mean that there aren't any arguable issues that careful issue spotting or a second opinion might reveal. We'll cover this in more detail during the client communication section, but as soon as you or your office is assigned to the appeal, you should write to your client and encourage them to share any issues that they want raised in their brief. You should keep these issues in mind as you systematically review the record. In your materials, we've provided an issue spotting guide with some issues to consider for criminal and family court appeals. And there are also a lot of resources on the ILS website that you can refer to for guidance on topic-specific issues. Today, I'm going to highlight some key issues to look for in plea cases. As a general matter, you should never file an Anders brief in a trial case because you can always at least argue that your client's conviction was against the weight of the evidence. So starting with some pretrial issues that you want to look out for. You want to look at any motions that defense counsel filed and that the court denied. You should also review the accusatory instrument and check that every count of the indictment charges an actual crime and alleges that your client committed every element of that crime. If there was an SCI, be sure that the SCI was properly executed and that your client was not charged with an A1 felony. You also want to look closely at the plea itself. Was it knowing, voluntary, and intelligent? Did your client admit to all elements of the crime? Did the plea colloquy negate any elements of the crime? Another thing you can look for is whether there was any evidence of ineffective assistance of counsel, or if the court, counsel, or the prosecutor ever misstated the maximum potential sentence your client faced, or any component of the plea agreement itself. Remember, even a weak plea-related issue can be non-frivolous, and you should never let a waiver of appeal stand in the way of appealing your client's conviction. There are many ways to challenge a waiver of appeal, and even if the waiver is found valid, there are still some appellate issues that survive even a valid waiver of appeal. There are also a number of sentencing issues to look out for. Did your client receive more than the minimum sentence? If so, you should always argue that the sentence was harsh and severe. This is true even if your client pled guilty as part of a negotiated plea agreement. Another thing to look out for is whether your client was sentenced as a predicate offender. If so, was the appropriate process followed in making that classification? And remember, if your client was younger than 21 at the time of the offense, you can ask for surcharges and fees to be waived. Over the last year, my office has summarized nearly 24 cases where an appellate court has waived surcharges and fees in the interest of justice. And so I also want to encourage you to keep up with the decisions of interest that the Statewide Appellate Support Center sends out every week so that you can be aware of trends in the appellate courts. If you've systematically gone through your record and you're on the fence about an issue or you don't see any issues to raise on appeal, get a second opinion. You can ask a colleague to review the record, or as I mentioned at the start of the presentation, you can reach out to the Statewide Appellate Support Center for a case consult. If you find yourself considering filing an Anders brief, we're always happy to take a look at your record to see if we can spot any issues for you to raise. Tom?
Okay, so let's talk about perhaps getting a stipulation to discontinue the appeal. You've taken the following steps. You still don't think that there's anything you can raise. So you've thoroughly reviewed the record. Like Sarah talked about, you've sought a second opinion, and you've discussed the case with your client. Okay, so how do you go about trying to get a stipulation to discontinue the appeal? Well, first of all, it's a conversation that you have with your client that's best done in person. It could be done over the phone, but like most important conversations, it's best if you can do it face to face. And if there's time, you should certainly write to your client ahead of time before either the visitation or the phone call so they can be prepared with whatever questions they have or with whatever issues they want to discuss. Slide, please. So what's the advantage of a stipulation to discontinue the appeal? Well, essentially, it negates all the problems that Anders briefs create. Okay, so there's no conflict of interest. You and your client are on the same page. You agree. The courts will accept it without question. Okay, it's much easier. It's just getting a signature. The conversation may be a little difficult, but the process itself is not hard at all. And there is no possibility of any reputational harm. So it's better in every way if you're trying to, if you don't think this appeal has any legs at all. Slide, please. So when you talk to your client and when you have this conversation, first of all, it might be a delicate one. Your client might be thinking, well, what's in it for me here? It sounds to me like you just don't want to do any work. And it's very possible that's what they're going to be thinking. So one thing that's really important before you've had this conversation is that you have developed your relationship with your client. Okay, so that means you've timely answered their letters, you've visited in person, and you've developed some trust and goodwill with your client, and that will pay dividends when you have this kind of conversation with your client, or any kind of more difficult conversation. But let's say you're going to talk to them about discontinuing. Okay, so first thing you do, always leave space for them to ask questions, to raise any issues, anything they think might be important or at least non-frivolous. All right, and keep an open mind. Maybe they'll come up with something that you hadn't considered. But if they don't, and if they haven't, then this is when you advise them and you reiterate how you've looked at all the issues you could have possibly considered. You enumerate them, I would think, and then you tell them why. Why can't they be raised on appeal? Okay, and then after that, another tack you might want to take is to ask your client questions about how the case unfolded. All right, so you've been looking at the record, but maybe there are issues that weren't on the record that might be something that you can discuss with your client. We're thinking about 440 issues now. Slide, please. So when we're talking about outside of the record issues to discuss with your client, we're primarily looking for issues related to ineffective assistance of counsel. Okay, many, if not most, 440 claims involve IAC. All right, most IAC claims won't be entirely on the record because that IAC, the analysis of that involves what's counsel's strategic choice, which is probably not going to be on the record. And besides, if it were on the record, you probably would have noticed it. So ergo, asking your client about things their attorney did or failed to do could be helpful. And, your client probably will have opinions about that. So one thing to make sure to ask, did their trial counsel fail to investigate potential witnesses that might have provided exculpatory testimony or perhaps impeachment testimony? Keeping in mind that the failure to investigate a witness is always a stronger IAC claim than deciding not to use one for whatever reason. Because if trial counsel fails to investigate, then they're not given the benefit of their strategic choice because there was no choice to make if they didn't have the information. If your client pled guilty, you'll want to talk to your client about what that conversation was like with their trial counsel. Some of the things Sarah mentioned, did they perhaps misstate the exposure involved or any other element of the plea? And there's some other potential 440 claims, perhaps police misconduct, whether or not there might be evidence that was failed to turn over that wasn't turned over that might have led to viable speedy trial claim. I mean, again, most of this is probably going to fall under the umbrella of IAC, as trial counsel, should have noticed and done something about it. Next slide, please. This might be an important reminder for us all that county law section 722 allows you to get paid for these things during the pendency of an appeal. If you investigate, file, or litigate CPL 440 claims, you can be compensated for that. So don't think you're just doing free work, okay? You should do the work anyway, even if you weren't being paid, but you are being paid. So it's a reminder, okay? This is a relatively new and I feel like underappreciated statute. Next slide, please. Okay, so You've scoured the record, you've sought out a second opinion, and you still haven't found any issues on appeal. Okay, now what? Well, of course, you let your client know all the things that you've done, how, just to be sure, you've talked to some, colleagues you trust, and they're not seeing anything either. And at this point, hopefully, you and your client will be on the same page about this, that there just simply aren't any viable issues for appeal. And at this point, you might say, I'm recommending we just discontinue it. Slide, please. What then are the next steps? Okay, if you're discussing it with your client, and if you're meeting in person, you can bring that stipulation with you. All right, but certainly I wouldn't pull that out right away, and certainly do not pressure your client into signing it. But one thing I would recommend is that by the end of that conversation, you've given them a time frame into which to make the decision, because it's certainly happened to me where you'll have a stipulation to discontinue sitting with your client, and you left a conversation thinking that they're certain to sign it, and it just sits there and it sits there and it sits there. So it's helpful to at least give them an expectation of when you'd like to see it back. All right, after that conversation you have, whether it's on the phone or in person, send a follow-up letter to your client detailing whatever you talked about, whatever you think your points of agreement were, along with your recommendation that they stipulate to discontinue, and again, give them a date for returning the signed stipulation to you. And Sarah's going to talk about client communication next.
Thanks, Tom. But before we do that, we have your first CLE code, and that is the number 9. So the first CLE code is the number 9, and I'll give you all just a second to write that down.
It's like that old Beatles song, number 9, number 9.
Yeah. Okay. So our next topic is client communication. Client communication is central to effective appellate advocacy. When developing your approach to client communication, you can look to the New York Rules of Professional Conduct for guidance on how an attorney is expected to communicate with clients. Rule 1.4 sets out a number of requirements for attorney communication, including that the attorney shall promptly inform the client about decisions that need to be made or material developments in the case, reasonably consult with the client about accomplishing the client's objectives, keep the client reasonably informed, and explain matters to the extent reasonably necessary to permit the client to make informed decisions. The ILS standards help translate Rule 1.4 into some concrete expectations. They reiterate that counsel should keep the client informed throughout the appellate proceedings and make clear that counsel should provide general information about the appellate process at the outset, keep clients informed about delays, provide clients with copies of documents, and respond to all client correspondence. Client communication is essential in appellate practice because many of our clients will go months or even more than a year without anything concrete happening with their appeal. If we don't proactively communicate with our clients, they may think that we don't care about their case or have abandoned their appeal. That's why it's important to write to your client after you or your office has been assigned to the appeal. In this first letter, you can introduce yourself and explain the appellate process and timeline. Be honest. You can explain that it will likely take you a few months to get the transcripts and necessary documents for the appeal. And if you or your office has a backlog of cases, offer an estimate as to how long it will take for someone to begin work on the client's brief. Even if you aren't ready to begin work on the case immediately, encourage your client to write to you with any issues they want raised in the brief. You don't need to evaluate the merits of those issues right away, but you should respond to the client and let them know that you will keep those issues in mind when you review the record. Communicating with your client from the outset will show your client that you take their case seriously and welcome their input throughout the process. This will enable you to build trust and better advocate for your client on appeal. So, what are the components of good client communication? We've covered a lot of the administrative components over the last few slides, but it's also important to make the most of any phone call or in-person meeting you have with your client. You can do this by asking open-ended questions and leaving space for your clients to tell you what they think is important to the case. Remember to listen to understand what your client is telling you. Don't just focus on formulating a response. And one thing I try to be very intentional about when talking to clients is avoiding legal jargon. Words and phrases that we use all the time, like preserved or interest of justice, can be confusing or even intimidating for clients. So instead of saying that issue is unpreserved, I'll say something like the appellate court can't look at that because it wasn't raised at trial. And instead of saying interest of justice, I might say the appellate court has some leeway to correct certain errors, even if they weren't raised at trial. Using plain language makes it easier for clients to actually understand what is happening. And importantly, it makes them more comfortable asking questions when they don't. And now Tom is going to talk about how to advise your clients about risks on appeal.
This is a huge part of the kinds of conversations you'll have with your client. And because winning on appeal doesn't always mean winning for your client. An appellate success does not always produce a better outcome. I feel like sometimes as appellate attorneys specifically, we can get hyper focused on legal wins. I mean, we don't get many of them, so we like them. And it's always good for us to make sure that we've taken that step back, because once we've taken that step back and looked at the bigger picture, we can help communicate that to our clients. So because other things, relief on appeal can reopen exposure. It can create more uncertainty. And so we have to focus on outcomes, not just legal error. Slide, please. Okay, so winning on appeal, risk factor one, maybe the most obvious one, you're starting over most of the time. So you've won on appeal, now what? We're going to be largely focusing on a reversal of pleas, because I feel like that's where the most risks come in for your client to consider. There are some for reversals on trials, but let's focus on pleas. The reality of a reversal on a plea where that plea is vacated is that usually does not mean that the case is dismissed. It usually means that your client is returning to their plea status. All the original exposure returns and they're back where they started. Slide, please. Starting over also means sentencing exposure starts all over. When the plea is reversed, what comes back? So any dismissed charges are revived. Anything dismissed in satisfaction of the plea, that comes back to life like a zombie. All the original sentence ranges apply. Maybe counts that were run concurrently could be run consecutively. And, there probably was a reason, hopefully a good reason, that your client accepted the original deal. And so these are things that you need to think about, and your client you need to make sure they're thinking about that as well. Slide, please. So one thing that your client has to understand is if their plea is vacated, there's no guarantee that they're going to get a similar kind of deal again. All right. Now, maybe at that moment, your client is not, they're not interested in getting the same deal again. That's why they want to appeal. They might not feel the same, however, after they find themselves in a situation that they haven't properly considered the risks about. But assuming there's no way to get the indictment dismissed, then here's where they find themselves. If they try to get the similar deal back, the situation might have changed. Different prosecutors might be handling the case. Human nature, you might harden positions in the DA's side because you're making them do more work. Now, sometimes that works the other way, where you make them do a lot of work and then they give you what you want. But there's no guarantee of that. And there's also the possibility that the institutional memory in the DA's office may be of your client just backing out. Okay, so your client needs to understand that this deal may be gone forever. And so this is maybe a bit of a digression, but I feel like it's kind of important to getting into your client's shoes and to understanding their thinking. And, it's something that I thought about when I started doing this work, which I was surprised by how many people wanted to appeal their pleas in the first place. If they just took the plea, maybe not even all that long ago, why now do they want to undo it? And so, I've thought about that over time. And I think part of it is the element of pressure that's involved when somebody takes a plea, maybe short of legal coercion, certainly, but there are times when the defendant can feel that everybody in the room wants them to take a plea, maybe the judge, the DA, maybe even their own attorney. And so maybe they capitulate to that pressure. Maybe that's why they took a plea. Maybe their family wants them to take it. And also, and this is something that I think is important to understand and to get into your client's headspace, is that at the time when they took the plea, they had two options that seemed equally real. They can either go to trial, and maybe they don't like the looks of that trial, and then they can get a lot of time at the back end of it if they lose. And on the other hand, they might not like this option either, but here they have a plea that they can take, which is a guarantee, and it's a lot less time. And in the moment when they make that decision, both options seem equally real. But after they have taken the plea and after they find themselves in state prison, now all of a sudden the consequence of the choice they made is very real. And they don't like it. They don't like the situation they're in. And I don't necessarily blame them. And now the thing that seems like less real and like the magic key to get them out of the situation they're in is a trial. And it's no longer they're thinking realistically, perhaps, about what that trial might look like. And so I think that this is a dynamic that you'll see over and over when you do appeals. And so it's just something to think about, like, why the heck do they want to undo their plea now? They just took it a month or two ago. So anyhow, I think that a bit of a digression, but I think that's worthwhile to get into our client's shoes. Next slide, please. Okay, so one thing that your client's going to need to understand, if they don't want another plea, then they're going to have some sense of the risks at trial. All right, and that means you will have to have some sense of the risks at trial, even though maybe you're not even a trial attorney. But it's something that they're going to have to think about when they think about whether or not they want to, if they want to risk vacating their plea. So it's hugely important engaging overall risk, and you have to have some idea of what that trial might look like. Okay, so you talk to your client about it naturally, and also make sure you review the discovery. Now, not just reviewing it with an appellate attorney's eye about how you might find IAC or anything else, but rather to have a sense of what a trial would look like for your client. Okay, and also very importantly, try to talk to the trial attorney. You should always try to talk to them anyway. And if there are trial attorneys out there, I'm sure there are many listening. Please talk to the appellate attorney on the case. Please give them your file. There's really no reason not to. But add that as an aside, talk to the trial attorney. Maybe there's something about the case that's not evident from the record. Maybe the trial attorney has some perspective on what a potential witness would look like. Maybe it wouldn't look good in a way that you could not tell by looking at the record. Okay, so you need to have some sense of what a trial would look like if your client were to take the risk to vacate their plea. Slide, please. Okay, another thing to ask your client, you didn't want to go to trial before. What is different? What might be different now that changes your mind? Are there any new witnesses for either side? Are any witnesses that would have been involved in the trial then, are they unavailable now? Are any potential witnesses newly impeachable? Maybe they picked up a new charge or something. Is there any new evidence that your client knows about? Are there any new legal theories for you and your client to discuss? So the point is, you have to at least have some sense of what's the probability of acquittal in a potential trial versus the risk of a harsher sentence. Next slide, please. Which leads us to a resentencing after trial. What's the risk of going to trial and losing? Well, perhaps obviously, the biggest risk is that there will almost certainly be a worse sentence than whatever the current plea sentence is that your client's serving if they go to trial and lose, guilty as charged. Okay, there's also a very important thing for us to think about, which is that your client could be potentially found a discretionary persistent offender. I think sometimes that seems like getting hit by lightning, but it's something that your client needs to know about, and you need to have noticed. Now, this is true whenever your client is going to be resentenced in whatever way. Okay, so just as a review, if your client has 2 or more felonies in their history, and this would convict them of a third, the judge can impose, after a hearing and some other things, a life sentence. So obviously that's a huge deal that you need to think about. Next slide, please. Another thing I know that I've talked to clients about, which is bail considerations after a potential reversal. Well, will I get bail if we're reversed? I know it's going to take a long time for the case to play out again, but will I be out on bail? And the answer is not necessarily. It really kind of depends on the issue that the reversal was based on. So clearly, reversals based on substantive issues will improve your chances. Substantive reversals, I don't know, there could be a lot of things, but perhaps erroneous evidentiary rulings, something of that nature, might influence the judge to improve whatever bail conditions there are. But on the other hand, if it's a technical reversal, something that the court is going to consider more technical, they probably won't improve your client's bail chances. Okay, I mean, maybe there was something like a K2 error when the judge didn't inform your client of some direct consequence of the plea. Maybe didn't inform him or her of post-release supervision or something. I don't know if the judge is going to feel like that's a big enough deal that they're going to improve the bail conditions for your client. Okay, so it kind of depends, and certainly it's not necessarily going to happen. Next slide, please. Some other things related to starting your case all over are complications related to custody. Okay, some practical issues. Your client may have established programming, work assignments, privileges that they've got lined up where they're being housed. There could be some benefits of their current prison placement versus being in jail while they await a retrial or await a trial of some sort. Maybe they have family visitation arrangements that are already in place that will have to be rearranged and reconsidered. The point is that there are different practical considerations that you and your client should be keeping in mind. Slide, please. Let's talk about risk category 2, illegal sentences versus illegal pleas. Okay, it's important to understand the difference. And this is a big one. If your client was sentenced illegally in any way, but the way that affects you is if it was illegally low, the appellate division will correct that, sua sponte. So nobody has to raise it. Certainly you wouldn't raise it. The DA doesn't have to raise it either. If the court notices it, they will correct it. Okay, and so if you have noticed that your client has been sentenced illegally low, then you might not want to appeal at all, because the courts they see this stuff. You're not gonna sneak it by them. And I see a question, wouldn't docs raise it? That might happen too. Okay, so the point is you're probably not going to sneak it by, and your client needs to understand this. But it's also important that you're clear about the difference between what's an illegal sentence and what might have been a plea that was illegally taken for whatever reason. Okay, and the difference is critical because on the one hand, while the courts will correct an illegal sentence, they will not undo an illegal plea. So so that's something to keep in mind, and there's established case law about that. Next slide, please. Risk category 3, let's call them emotional and psychological costs, non-legal things to think about. All right. Always being concerned about taking a paternalistic approach to what's right for your client. But nonetheless, I think part of our counseling role includes considering the collateral impacts of whatever legal decision is about to be made. And part of that is, might be a psychological benefit to having closure, acceptance of that fact. I think everybody's had the experience of having a client say, I just want to put this behind me, and that's basically what they mean. And I raise this primarily so we understand our client when they might be reluctant to take a risk that we might personally seems worth it. It seems worth it to do this. Why don't they want to do this? Well, part of it might be that emotional and psychological cost that's harder for us to measure because it's not happening to us. So it's good to be aware of these things. It's good to be aware that your client may have optimized their situation, where they're being incarcerated. Maybe to them, the stability and the routine matters in terms of, the life that they're living now. And so these things are something that we need to keep in mind when we're talking to our client. And so we really understand what their concerns are, because that's ultimately what we're doing, is we're trying to help them make decisions given their legal situation and given what's important to them. Next slide, please. Okay, kind of sort of by way of summation, what your client needs to understand with regards to a plea reversal and when their plea might be vacated, when that's what we're discussing. One, there's a difference between reversing and vacating a plea versus dismissing the indictment. All right, that's incredibly important that they understand that. And then they need to understand that their time horizon for the relief they're hoping for is going to be a long one. Even if it's ultimately successful, they're going to have to wait a while, and they might not be out on bail either. They need to understand the exposure that they've just reopened themselves up to, the minimums, the maximums, and their predicate offender status. They need to understand that there's probably not some third way. Reversal usually means either they're going to trial or they're finding some other plea that they're hoping to get. Okay, there's no magical third path, Clintonian third path here. Almost never. Okay, when we're talking about vacating a plea. They need to understand that losing at trial almost certainly means getting a longer sentence. And then while they're thinking about that risk, they have to think about whether there's any chance that there's any reason to believe that their chances at trial have improved since the first time they decided they didn't want to go to trial. Next slide, please. So what are some strategies for having these kinds of conversations about risk? Because they can be hard. And how can we make them better? Slide. So one thing we can do, I think, is what I'm calling building partnership through your use of language. Okay, and this is a simple thing. And this works whether you're an appellate attorney or a trial attorney. And one thing you can do is just get in the habit of using we and us language. Okay, so that signals, whose side you're on. You're on their side. Okay, it starts to, just subtly lower defensiveness, I think, in your client before you have the discussion about risk and while you're having it. And it kind of emphasizes the shared decision-making aspect of this. So one thing I do want to put in a caveat right away, which is when I say shared decision-making, I mean more in the sense of collaborative, because as we know, the law does define who gets the final say about certain decisions. And, it's important that everyone understands that in that conversation with your client. So we know that your client has the ultimate authority whether to accept or reject a plea, whether to testify at trial, whether to waive the right to a grand jury, and important here, whether to appeal a judgment. Okay, so and all, as we know, all other decisions about strategy and everything else belong to us as the attorney. So, but I think, having said all that, I think it is important that they understand that that we're a team here, and we're trying to come up with the best decision we can together. Next slide, please. So how about some simple examples of this? It's really easy to do. So it costs you almost nothing. So you can say things like, well, let's walk through what happened if we succeed on appeal. Or, I'm just thinking, what are we hoping to achieve by this? Or how does that risk affect our strategy? Okay. Sometimes it's important to acknowledge that the consequences of whatever you're going to do fall on your client. They don't fall on you. So don't overdo this. At times it might be appropriate to say, look, it's easy for me to say that, maybe you've got a client who has got a conditional release date in 7 years, and they're potentially opening themselves up to a lot of time if they went on appeal. And at some point in that conversation, and you're thinking, man, that's 7 years. That seems a lot better than what you're probably looking at if you appeal. But you might say to them, well, it's easy for me to say 7 years. I'm not the one sitting in prison. So it's easy for me to say that 7 years seems a lot better. So I acknowledge that. Nonetheless, so occasional acknowledgement that no, you're not the one that's facing these consequences. Your client is. I think they'll appreciate that. Next slide, please. Okay, how about some more strategies for this kind of discussion? Creating safety for honest dialogue. Now, I'm getting this from sort of a trendy book, Crucial Conversations. I don't normally like these kind of books, but I found this to be quite helpful, actually, and quite applicable to what we do as attorneys and as appellate attorneys. So one of those ideas in these kinds of conversations, when you're going to have a conversation that's difficult, and you want to make sure it goes as well as it can, one of the principles is you establish mutual purpose early in the conversation. Okay, and what's an example of that? You might say, we both want the best possible outcome here. Let's figure out what that looks like. So it shows, you have a shared goal. You might not agree on the tactics, but you have a shared goal here, okay? And you communicate that to your client early on before you start this conversation. And while you're having the conversation, look for signs from your client. Look for signs of withdrawal. Look for signs of silence. Because if you see your client shut down or become defensive, you should pause. Pause to restore what the book calls to restore safety. And it's essentially to reestablish trust. Okay? Because, so going to the third point, make it safe to disagree. Make this an open space for conversation. So you can say things like, I want to share my concerns, but this is your decision. And I need you to feel comfortable pushing back against my reasoning if you don't agree with it. All right? Because clients, when they feel safe to disagree with you, they're more likely to trust you. They're more likely to share information and concerns that you need to know if you're going to give them truly informed counsel. So make it safe to disagree. Oh, and by the way, all these points that I'm talking about in terms of conversational strategies, it's not just for one-on-one, oral conversations. I think you can incorporate some of these things into letters as well. If you're writing a letter where you're going to say something that they're not going to want to hear, establish your mutual purpose early. And show some humility and say, look, you might not agree with what I'm saying, and please let me know if you don't. So these things also work in a written medium. Next slide, please. Another concept from Crucial Concepts that I think really kind of works is to make sure you separate facts from story and to stick to the facts as much as possible. And what I mean by story is like the interpretation um, that we will put on facts. Okay, so try to avoid those as much as you can. So, an example of sticking to the facts might be if we went on appeal, the prosecution has the option to retry you. You could face from 15 to 25 years if you're found guilty. And right now, your conditional release date is in 7 years. Okay, those facts kind of speak for themselves. Versus putting in the version of a story is like, if we win and then you lose a trial, you're going to get tons more time and you're going to regret it. Okay, that doesn't work as well in these kind of conversations. It's going to be alienating to your client. Okay, even if you think that's true, it's probably not the best way to go about convincing them, or at least making sure they understand what's truly at stake. Next slide, please. Okay, another thing is like you're going to disagree with your client about these things sometimes. And how do you manage that disagreement without falling into paternalism? Um, it's our job to counsel effectively, but without coercion, without fear mongering, and conversely, without abdication. What I mean by that is just saying, well, I don't know, your choice, man. You know, sometimes I feel like attorneys are a little too quick to just give it up to their client and not offer their opinion when it's appropriate and when it's asked for. And I think about going to a doctor, and the doctor talks about whether or not you're going to need heart surgery. At some point, you want the doctor to weigh in. The doctor's the expert. So on the things that they know more about than you, I want their opinion. Okay, I don't want them to say, "Hey, man, I don't know, you get heart surgery or not. That's up to you." Okay, so that's what I mean by abdication. It's still your role to get in there with your client and really, and if giving your opinion is called for, then you shouldn't be afraid to do it. On the other hand, you should resist the urge to win the argument. Okay, that's not the goal here. The goal is to get informed consent and not agreement. It's like we want everyone to understand and that they understand what they're up against. To that end, we should use consequences, not conclusions. Similar to stories versus facts. Here's what happens if we win versus, man, this is just a bad idea. Don't do it. And one thing, very important, uh, you should document these kinds of discussions carefully, okay? Especially where the risks are substantial. You should ultimately have them sign some kind of a risk acknowledgement form that you've sent to them where you spell out, I want you to appeal these issues, um, understanding the risks involved that you've laid out, or, maybe I just want to challenge the sentence as being harsh and excessive. Okay, so, I don't know that we have an example of that in our materials, but it's important to get these things documented. Okay, you don't want any funny business after it happens. And also be prepared to revisit their decision about risks over time as their minds change, as the posture of the case changes in some ways. Maybe they get released on parole or something. That might change how they feel about it, or in whatever way the leverage of the case changes. It's not a make the decision once, it's decided forever necessarily. And with that, let's turn it over to Sarah.
Thanks, Tom. So now we're going to touch on some difficult questions that your clients will inevitably ask you. An important thing to keep in mind is that when clients ask these questions, they're trying to understand what's happening to them, what the various outcomes may be, and what control they still have in this process. These questions often come from frustration, disappointment, or fear. So, a common question that comes up is when a client wants to argue an issue that's based on something outside of the record. Our clients usually don't realize that the appellate court is limited to the record that was created in the trial court and that judges aren't allowed to consider new facts, even if those facts are important. I usually explain this by telling the client that the appeal is a review of what happened at the trial court. And on appeal, we're limited to the information that was in front of the judge at the time that they pled guilty or were convicted after trial. This means that we can rely on information that was in the transcripts of the proceedings, the motions, and other papers that were filed with the court, and the exhibits that were received into evidence during a hearing or a trial. If an issue relies on facts that aren't within those files, the appellate court can't consider it. Tom?
Sorry. Okay. Let's see. Where are we? Hold on a second. I'm in the wrong spot here. Why can't yes. Okay. Why can't we argue whatever issue that we know has been waived by the client's guilty plea? There are a bunch of them. Okay. So one thing you should start to do is explain what waiver is, but without blame. You don't want to lead with, well, if you wanted to do that, maybe you shouldn't have pled guilty. Okay. You don't want to have anything that has a whiff of that. So say something, I would say something more along the lines of, well, when you plead guilty, the law presumes you're getting something out of it. You're getting certainty and a better sentence than if you lost a trial. But the trade-off is that the law will consider a lot of the issues as resolved, and therefore we can't bring them up on appeal. Okay, so start by explaining what it means that something's waived, but without making them, without it making it sound like you're blaming them for pleading guilty in the first place. And the second thing I would do is I would set expectations. So you've kind of started to do that, but you say, well, after a plea, the road on appeal gets narrower and harder. So I might mention some of the issues that get waived, something like statute of limitations, sufficiency of the evidence for the grand jury. I feel like I've got that question a lot, and it's one that's waived by the guilty plea. So I'll talk about some of the other things that are waived by guilty plea, and then I'll say, and unfortunately, the issue that you're talking about now is one of those issues that's waived. Okay, but then the important part is, you don't want to linger on that too long. Then I think you want to pivot. You want to pivot to the things that we still can do, and hopefully there are some. And you'll say, well, but one thing that's not waived is that your plea was not made knowingly, intelligently. And that's why we've been working on that. That's why we've been talking about that. Or maybe you've got a speedy trial issue or a jurisdictional defect or maybe the harsh and excessive sentence you hope to argue. So I think it's, when you move away from what they can't do, move into what you can. So they feel like you're not just telling them we can't do anything. You're giving them advice about the things that you can do. Okay. And and this might be a moment where that they're feeling that it's unfair what has happened. And this could come up in a lot of different contexts, but let's say that they're like, well, why is that? That's not fair. Why can I not have that? And I think what you do in that situation is you acknowledge the unfairness of it. You can say, I know it sucks. I know that's true. I agree with you. But the problem is, if I raised it, it's not that there's not a good chance that the court will rule for us. It's that they are not legally allowed to. So, I don't have any problem raising an issue that's not a great issue, but there's literally no way that the court can do what we want them to do. And I think if we were to raise the issue, that doesn't help us. And if anything, it might hurt us because the court will wonder why I'm raising an issue that I should know is waived. And I don't want to destroy my credibility because that might ultimately affect your case as well. Okay, so, and emphasize, you tell them that, look, I'm here to help you in whatever way I can, but I need to tell you about the limits of what we can do right now. So it's about preserving trust, managing expectations. And just a few things maybe not to say, do's and don'ts. So I would avoid saying things like, well, you gave up those rights, or, which obviously sounds accusatory, or, well, that's just the law, which shuts down the conversation and it sort of closes off the relationship versus the opposite, which is what you want. Instead, you can say things like, the law limits what can be reviewed after a plea. All right, it's a nicer way to say it. Or, the court is not able to reach that issue. So just think about that. Think about the way you put things. You can communicate the same information in a way that's much less alienating and off-putting to your client. Okay, Sarah?
Okay, so another question that a client may ask you is, why can't we argue that I'm innocent? This is a good question to address, even if your client doesn't ask it directly. A few years ago, I had some challenging conversations with a client who I eventually realized was looking for the appellate court to say that he was innocent. Once I understood that, I was able to explain that the appellate court wasn't there to decide if he was guilty or innocent. Instead, the appellate court was deciding whether there were legal issues and how the case was handled at the trial level. So this meant that the appellate court could decide whether his sentence was harsh and severe, whether the trial court made a bad ruling, whether he was denied the effective assistance of counsel, whether the evidence against him was legally sufficient, and whether there was enough evidence to support his conviction. Once I explained the decisions that the appellate court could make, the client was able to adjust his expectations for the appeal, and we were able to have a more productive conversation about the issues that we would raise in his brief. And after that experience, I made sure to explain to all of my clients early in our first conversation what decisions the appellate court could and could not make.
All right, another question. We've kind of been circling around this a little bit, but what happens if we succeed in vacating my guilty plea? Okay, and this is where you're going to get this. You're clearly going to get this question, and this is where you explain all the things that we've talked about earlier. You're back where you started. The case is not going to be dismissed. All right, and very often clients will have not understood that before you had this conversation. And it's probably not welcome news. As soon as they think, well, reversal on appeal, they think the case is going away. So this might be the first time that they've considered that. And then when you get this question, you'll tell them, you'll have to decide if you want to go to trial or if you want to get another offer from the prosecutor. And maybe this is when you start getting into the risk factors that we discussed. I would probably caution against, being too hasty about all the risk factors. When they just ask you what happens, I don't know that it's the best idea to then launch into all the bad things that can happen. Let them process this information first, because it's quite possible that they thought the case would get dismissed outright. So, you don't want to pile on at this moment. But this is when you want to, make sure they understand that if we get the guilty plea vacated, it's going to take a lot more time, all right? And also, it is going to involve risk. And so maybe then you can begin to talk about what those risks are. Sarah?
Okay. So another question that a client may ask you, or an issue that might come up, is when a client wants you to cite to a particular case, but that case isn't related to the issues in your client's appeal or is now bad law. I always want clients to know that I appreciate their contributions to the appeal and take their input seriously. So I'll usually start by acknowledging their effort and thanking them for looking into the issue and finding the case for me. Then, depending on your client, you'll want to approach this a bit differently. But wherever possible, I'll cite to a case a client has sent to me, even if only in a string cite. And if the case is no longer good law or isn't relevant to the issues that we're raising on appeal, I'll explain to the client why that is, and I'll tell the client that if we rely on a case that doesn't fit the facts or issues in their appeal, it could actually weaken our argument rather than help it. I then try to find another case that gives voice to the issue that the client wants to raise. Show that case to the client and ask the client how the client feels about citing to that case instead. And usually working that way, we're able to resolve that issue pretty pretty easily. Tom?
All right. Question you might get. If the court dismisses the charges against me, can I be prosecuted again? And so if you get this question, first of all, make sure you're clear on what your client means. Okay, so sometimes if they're talking about getting the charges dismissed in this context, like sometimes clients think that, for example, getting the charges dismissed in satisfaction of a plea are gone forever, even if the plea gets vacated. Okay, and you have to explain to them, unfortunately, that's not true. If a plea gets vacated, the dismissed charges come back. I've had several conversations with clients where when we're talking about the plea, but that got dismissed. And I'm saying, well, yeah, but if we get the plea vacated, it's coming back. Okay, so make sure you understand, you know what they mean by dismiss the charges, because otherwise maybe they mean something different. And you might have to give them the dreaded, well, it depends. You know, it depends on why it gets dismissed. So for example, you know, sometimes yes, sometimes no. If it's a trial appeal and the charges were dismissed based on legal insufficiency or as being against the weight of the evidence, then it's, you know, it's true. You cannot be re-prosecuted on those charges. They're either going to be dismissed or they're going to be reduced to the lowest or the next possible charge that the evidence supports. Now, with the caveat, if it's found to be against the weight of the evidence, departments 1, 2, and 3 will reduce it to the highest charge that the evidence can support. But if it's the fourth department, no, kind of interestingly, but keep that in mind. So that's an example where you cannot be prosecuted again if the charges are dismissed, if that's what your client means. But, you know, keep in mind that when they say something gets dismissed, they might be speaking rather loosely. They might just be talking about, you know, other kinds of reversals based on legal errors, most of which will, you know, just result in a new trial, you know, not a dismissal of the accusatory instrument. Okay, there are some that aren't. Speedy trial, dismissals, you know, certain jurisdictional defects, or maybe a suppression ruling, which would render the rest of the evidence on a charge insufficient, that kind of stuff. So in sum, if you get this kind of question, one, make sure you understand what your client means by dismissed charges. Two, if it's a plea reversal, make sure they understand that those charges come back. And then three, you got to give them it depends, and then make sure you're clear on the answer. Okay, and we're going to talk about a question where maybe you're not clear on an answer. How do you handle that? But though that would be my advice when you get that kind of question.
How's that, Tom?
Yep. Sorry.
Okay, no worries. So what happens if we lose? That's a fairly common question, and unfortunately in criminal appeals, a situation that we face often. When my clients ask this, I explain that if the appellate court affirms their conviction, I'll write to the Court of Appeals and ask them for permission to appeal the client's case in their court. I always advise clients that this is a long shot because the Court of Appeals doesn't accept many criminal cases. I'll then explain that if the Court of Appeals denies our request to appeal the client's case in their court, then that's the end of the client's state court remedies, but that they can still try to appeal their case in federal court. This may differ based on whether you work for an institutional provider or are a solo practitioner, but when I worked for an institutional provider, I told my clients that the representation would end if the Court of Appeals denied leave, but that my office would provide them with information about who they could reach out to if they wanted to challenge their conviction in federal court.
Okay. All right. Your client asks a question you don't know how to answer. That's never fun. But let's just say, if you don't know the answer, don't hazard a guess. Okay, so accuracy beats confidence. All right, never guess if you don't know. You know, strong and wrong is way worse than taking an honest pause. And there's some strategies when that happens. Well, first of all, if you if you do just give a confident and wrong answer, what are the consequences? One, you undermine the trust your client has in you. And two, you might open yourself up to ineffective assistance or grievance exposure. Uh, those things aren't good. So don't answer a question if you don't know the answer, but also normalize not knowing. There's a lot of things to know that we do, and you can't be expected to have it all rock solid off the top of your head. So you want to be able to normalize not knowing, but without sounding incompetent. So you can avoid saying, I don't know, but instead you can say, that's a good and important question. And I don't want to guess. So let me research that and let me get back to you with a reliable answer. All right. So that communicates professional care and doesn't communicate incompetence. All right. Um, Second, I think you get this kind of question, you want to show that you understand the question. And, so paraphrase their concern. What I understand you saying is, and then paraphrase whatever it is they just asked you. So, first off, occasionally paraphrasing what your clients say to you in any kind of conversation or interview is always good technique for client relationships. Okay, it makes your client feel heard. You can confirm that you actually do understand. Maybe you didn't understand when you say it out loud, and then they can say, no, that's not quite what I meant. So you confirm whether you understand what they're talking about. And also, it shows that you understand the stakes, even though if you might not know the answer just yet, you understand why they're asking and you understand why it's important. And then, of course, commit to a follow-up and, follow through on it. So say something like, and not just like that you'll do it, but when you'll do it and how you'll do it. So you could say, okay, I don't know right now, but I'll research the statute and the law, and I'll send you a letter within a week or two, whatever's a reasonable time frame. Okay, so you tell them how you're going to respond and when you're going to respond, and then of course you better respond. And this can be tied to the New York Rules of Professional Conduct. So Rule 1.1 is about competence. Rule 1.4 is duty to communicate. Rule 1.3 is diligence. And when you take an honest pause to research a question you don't know the answer to, you've done all three of those things. All right. So that you're also, that's ethically what you should do as well. So what might be a short, no-nonsense answer to the question that you don't know how to answer? You could say, that's a good question, and I want to be careful here. The answer depends on a few specific legal factors, and I don't want to give you an off-the-cuff answer that could be wrong. Let me research it, and I'll get back to you next week with a clear, accurate answer. Okay, does that work for you? And hopefully they'll say yes. And obviously, it's uncomfortable to not know a bunch of different things in a conversation, but, and that happens, especially if you're just starting off. But as you go on, it'll happen less often. But when you do, I think if you try it in this way, it will be effective for you. Sarah?
Thanks, Tom. So another question you might get is, can I get a new lawyer? If a client asks me whether they could get a new lawyer, the first thing I would try to do is connect with the client and try to understand what's going on. If the issue came up by letter rather than during a phone call or a legal visit, I would set up a legal phone call with the client so that we could talk more easily. And I'd write to let the client know that I'd set up a time for us to talk by phone. Then when I spoke to the client, I would ask if they could tell me why they were interested in having a new lawyer. Because very often the request isn't really about wanting a different attorney. It's about feeling unheard, confused, or frustrated with the process. The issue might also be about communication. The client wanted more frequent updates, or maybe the client didn't understand why certain arguments couldn't be raised on appeal. Or maybe the client is frustrated at how long the process takes. Once you identify what's behind the request for a new attorney, you can often resolve the underlying concern and answer any unanswered questions that the client was harboring. And if that doesn't work, you can explain that in assigned cases, a new lawyer is usually only appointed if there's a conflict or a serious breakdown in communication. But definitely start by trying to connect with your client. That's the first and best route to go. Tom?
What would you do if you were me? Um, I feel like that's a question I've definitely got, and it kind of gets at the heart of a few different things. It gets to the heart of client autonomy, the uncertainty that they're facing, and also the boundaries of our roles as the client and as the attorney. So, but when you think about it, the heart of what they're asking really is, I think, the sort of the emotional heart of that question, what would you do if you were me? One, it's asking, can you really understand what it's like to be in this situation, attorney person? Do you know what it's like to be facing what I'm facing? That's kind of the meat of it. That, and also, I think the second part of it is, can I trust you? Can I trust you to give me wise and reliable counsel in this situation? I think that that's the heart of what this question kind of is. And there might be different ways to do it, the different ways to handle it. The first thing I would do is acknowledge the question and not dodge it. So I wouldn't say, I can't answer that. I mean, maybe that's the truth, but I wouldn't start off by saying that. I think I would say something more like, well, I understand why you're asking that, and I want to answer in a way that's going to help you. Okay. It's a way to keep the rapport with your client while preserving boundaries in the sense that our decision making here is not the same because I am not the client. I'm trying to help them come to the best decision they can, but I am not that person. All right. So you might want to consider reframing the question around the client's priorities might be one strategy to handle it. You can turn me back into you. And what I mean by that is you could say, well, what I would do depends most on what matters to you most. What matters to you most? Is it certainty? Is it minimizing exposure? Or just taking a chance to get out of prison, even if it's risky. So what I would do depends on what matters most to you. So that's one way of kind of, turning it back on them a little bit. You also might want to consider whatever guidance you give to be conditional and non-directive, saying things like, if avoiding a worse outcome is your top priority, then, not appealing probably makes the most sense. You can kind of, you give them guidance without, if you're not comfortable falling into I don't want to call it a trap, but if you're not comfortable saying, well, if I were you, I would do this or I would do that. I don't know. I'd be wary of that personally. You can say something like that. Maybe a model kind of answer would be something like, what would you do if you were me? You could say, well, I understand why you're asking that. And what I would do depends on what matters most to you. I mean, if your main goal is certainty and avoiding risk of a worse outcome, I think maybe it makes sense not to appeal. On the other hand, if, correcting the issue is important enough to you that you're willing to accept some risk, then, we could consider appealing. And I think, that wouldn't be a bad choice either. Continuing to use your us and we language, continuing to emphasize shared goals and stuff like that I talked about with the crucial conversations. But then ultimately you can say something like, my job is to make sure you understand the risks and the benefits, so you can best choose what makes most sense for you. Okay. So the point, the most safest and professional answer is the one that helps them decide and doesn't purport to decide for them. So that would be my advice. Sarah?
Thanks, Tom. Okay, so we have our last CLE code for you. It's the number 2 o'clock. That's when we will be wrapping up this CLE. So our CLE code is 2, and we have just one more brief topic to go over. So just write that down. CLE code 2. Oh, 2 and 2. Perfect. Okay. So a lot of the questions that we were just talking about can be difficult to answer because of the human stakes behind them. And that reality becomes even more pronounced when the client's ability to understand, process, or participate in the representation itself is limited. And that brings us to our final topic today, which is representing clients with diminished capacity. What should you do when you realize your client has diminished capacity? Diminished capacity can cover so many different situations and diagnoses, and what we really mean is that something is going on cognitively or emotionally, and you're struggling to connect with the client. You may learn that your client has diminished capacity from the record, from information from a third party like trial counsel, or from your own personal interactions with the client. This will look different for every client, so it's crucial that you identify the nature of your client's diminished capacity, and to the extent possible, talk to your client about what sorts of accommodations they might need. The Prison Policy Initiative reports that 43% of people in state prisons and 44% of people in locally run jails have been diagnosed with a mental disorder. And so it's very likely that you already have or will represent a client with diminished capacity. We don't have time to go thoroughly into this topic today, but I wanted to briefly touch on it and make you aware of the resources that you can refer to and people you can reach out to when you represent a client with diminished capacity. I've included some materials in your handouts, and there are also a few places you can look to for guidance in representing clients with diminished capacity. There's Rule 1.14 of the New York Rules of Professional Conduct, the ABA Criminal Justice Standards on Mental Health, and the ILS Appellate Standards. The most important thing to keep in mind when representing clients with a diminished capacity is that wherever possible, you want to maintain a conventional relationship with the client, because a client with diminished capacity often still has the ability to understand, deliberate upon, and reach conclusions about matters affecting their own well-being. This means that you still have the same duties and obligations to the client, and you should endeavor to provide them with the same information and advice as any other client. But you may need to change your approach. In these cases, it can be helpful to pair up with someone who has more experience, so you may want to consider collaborating with a social worker or a mitigation specialist. The most important thing is to recognize when your client may have diminished capacity and adjust your approach accordingly. Okay, and now we have a few minutes if anyone has questions.
Hey, Sarah, we did get a couple questions through the chat. I know a couple of them were answered, so I'm going to go over the ones that weren't answered first. We have an attorney who says that they would like to visit their clients, but they don't get reimbursed for the visit, I guess. At best, they get mileage. Do you have any suggestions for that? I think that's a great question.
That's too bad, first of all. I would say, let me take a crack at this, Sarah, and you please jump in if you have anything to say about it. So I think visiting is always best practices, at least once on an appeal. Where I used to work at Hiscox Legal Aid, that was a rule. Second best is going to be phone calls. So, I would maybe consider, okay, you're not getting paid for it. Maybe it's the cost of doing business, the way paying for your Lexus contract or whatever is a cost of doing business, to do the job that you need to do. So some of my advice might be in that sort of vein. But otherwise, if you truly don't get reimbursed for it, make up for it with, you get a phone call a month with your incarcerated client, do one every month then. If I think that would go a long way to, sort of really establishing your relationship with your client. So those are a couple things that pop into my head.
Yeah, I just want to echo what Tom said. I think it's really important to talk to your client. So if taking the time to visit your client, and if you're not getting reimbursed for that, it's still important to have that conversation, make that personal connection. And so a way to still talk to your client and have that conversation without taking as much time as a phone call. And so I would at the very least do that and have a phone call with your client. I think it's really important.
And we have a commenter who says that they can get reimbursed for the time, but not the travel time. So that's something. Also, Tom, I'm not sure if you're referring to the monthly call with respect to the old docs rules, but docs doesn't have the 30-day rule anymore. So
even better.
Yeah.
Even better.
There was
Call them
another
once
question
a week
that I
till
thought
they're
was
tired of you talking to
interesting.
them.
Yeah, there was one other question that I'd like to try to get before we jump off, and certainly people are free to stay on. But the question was whether you guys think it matters if the attorney's female, and is there any difference in tactics in that situation?
I love that question. And Sarah, I will let you take a first stab at that.
Sure. I don't know if that was like in response to a like particular topic we were talking about or a particular question we were addressing, but I think I found in general that clients are a lot nicer to me than they may be with some of my male colleagues. I know I shared a client with one of our parole attorneys at Hiscox Legal Aid, and whenever I talked to the client, he was really nice and friendly. We had a great conversation. But whenever the parole attorney talked to him, he would be yelling at the client, or he would be yelling at the attorney and really upset with him. And when the attorney asked him, I hear you're so nice to Sarah, like why are you yelling at me? And the client said that he doesn't yell at women. So I think I found that clients are generally nicer to me maybe than they might be to male colleagues. But I I think that's the only difference I've seen. Tom?
Well, my thought is, who you are and how you present always matters in some way. Now, I'm aware that I'm probably allowed to I have a certain style with my clients, and this is a conversation I have with my students as well when they're developing their style. They're a lawyerly style with their client. Like, I feel like I'm given leeway in certain ways. I'm a like classic white dude. I'm allowed to be a little more informal if I want. I'm allowed, to do things that maybe other people aren't just automatically given license to do. And so I think it's probably is important to think about the different things you bring to the conversation. If you're female or if you're male, if you're white or you're black, whatever it might be, those are realities that you have to sort of consider. I think, obviously you don't want to go, you got to be who you are. Of course, you got to be who you are. So I don't know. Maybe it does matter in some ways, being a female coming to the conversation. Now, if the commenter's question came like during the crucial conversations part of our presentation, I don't think it would probably matter too much there. Those are just, I think, just good conversational strategies using us versus, us and we language. All that stuff I think would matter, wouldn't change by who you are. I do think that these things do kind of matter in different ways, but maybe not in some of the things that we had been talking about. Is my off the cuff response.
And just to
Great.
jump off of, oh, if I could quickly jump off of something Tom said about how he is able to be a bit more informal. I know that for me as a woman, and also when I was first starting, I know I come across as a lot younger, especially then. So I would always dress formally. I would wear, my blazer and dress pants for whenever I visited clients for all those legal visits. Whereas perhaps somebody in a different situation might be able to get away with dressing a bit more informally then.
Yeah, and to be clear, I don't show up to client conversations in my sweats. This is more like informal in terms of my demeanor. Maybe I drop an F-bomb in an inappropriate spot or whatever. So I know that I could maybe I get away with a little bit more just because of who I am.
These are great tips. It is 2 o'clock, so I just want to remind attendees, get your CLE forms with the 2 codes that you received today to Lily by February 6th, I believe was what she said in her email. I understand people have to leave, but I do want to, if you want to stay on, I can go over some of the other points that were made in the chat. But thank you all for attending. We hope to see you in March.
Thanks, everybody.
Yep.
Thanks.
Sarah, I think you answered this question in the chat. It was Phil's question about citations for where Anders have been filed in family court briefs.
Okay,
and I think you said there was some citations in the materials, right?
Yeah, whichever case is like the matter of whoever versus whoever, that's the family court ones. And I think there
Okay.
should be at least 2 or 3 cited there.
And I was just addressing that. I know you addressed it in the chat, but in case people were not following the chat, I wanted to make sure that people were aware that it was there. And this was just a comment that the Court of Appeals in People v. Tiger made it clear that they really don't care about actual innocence if you've pled guilty. So that's something to keep in mind when you're talking about that issue with your clients. Let's see. I think that's it for questions. There's some comments in there, and we're happy to get those to you if you guys want them. But I think we're all set here.
Thank you so much, everyone.
Awesome.
right.
Thank you.
Thank you, guys. Have a good one.
Bye-bye.
You too. Bye.
Thank you.